And welcome to today's segment of The Power of Money. I'm your host, Michelle Graves, nationally and internationally known for the last 36 years as the Money Lady, and I remain committed to bringing you the very best of financial information, health, and wellness issues as they impact on our community. And today we are continuing on an interview that I had several weeks ago that was so profound that I had to revisit it to finish up what we didn't get done. So, for those of you that didn't get to see it air, please feel free to visit youtube.com/the power of money and look for elder financial abuse under my channel, and you will see part 1. Today is part 2, and I brought back my guests from part 1, which is Craig Matthews, attorney at law, and Tom Fields, who is Ohio Director of the National Organization to End Elder Financial Abuse. Two amazing and knowledgeable individuals about this absolutely horrific situation. And I say that in all candor. It's just out of control. It's out of control. It's out of control. So today we're gonna focus on conservatorships and guardianship issues. And now don't start fanning. It's worth you sitting down and listening, because the truth of the matter is it could happen to you. And I really do mean it. It's just that bizarre. So without a lot of fanfare, I'm going to reintroduce my guests, and we're going to get into the subject matter today. Craig Matthews is an attorney. He is my first spokesperson. He has advocated for victims of elder fraud for more than 25 years. He has recovered more than $1 million for a single victim, one of the largest elder fraud recoveries in Ohio ever. He was awarded a Top 100 Ohio Litigator designation by the American Society of Legal Advocates. He is rated, quote, AV preeminent by Martindale-Hubbell, the nation's oldest professional peer rating organization. He has published numerous articles on elder fraud and senior citizen financial abuse. He has spoken to professional and lay groups on the topic many times, and he maintains offices in Dayton, Ohio, and Cincinnati, Ohio. This is Craig Matthews. My second guest is Tom Fields. And Tom Fields is State Director of the Ohio National Association to End Elder Financial Abuse. And just to restate what I said last time, Mr. Fields was rudely awakened to how older adults are financially exploited when his father died in 1991. His father, Irving Fields, passed away then as a result of cancer that had been diagnosed and treated months earlier. Just hours before he died, while on a morphine drip and under a doctor's do not resuscitate order, Irving signed 2 financial documents which contradicted one another. The last document contradicted not only the first one, but also the will and trust documents which Irving kept in a bank vault, as well as law firm records of attorneys who showed up with this last document for him to sign, a document which benefited the family of one of the lawyers. Doctors were involved in these events, the last one admitting under oath that what he did as a favor for the lawyer, who was a friend and whom he thought was acting as a spokesman for Irving, not knowing that just 2 days earlier, Irving had told other lawyers not only that he had extreme distrust for this lawyer, but also that this lawyer had been trying to get him to sign documents which he had refused to sign. I can go on about Mr. Fields' experience, but just know that he is a strong advocate of legal reforms which will protect individuals with severe cognitive impairment from being taken advantage of. And so we begin on that note talking about part 2 of elder financial abuse. And I'd like to begin by showing a video to our viewers, and then we will go back to the show itself.
Yeah. I want to go home. Go to your house. I can't stand to stay here any longer, Diane. You gotta help me.
I know, Mom. I'm trying to. I'm trying to help you. I'm doing everything I can.
But nothing's happening.
I know, because they don't want anything to happen. I
They
filed
don't
them.
want me what?
They don't want anything to happen. The guardian and the judge want you to be in here.
I don't want to be here.
I know you don't.
I don't want to. I'm not going to eat or nothing anymore.
You don't want to make yourself sick. You
I'm
want
not
to
going to
eat.
stay. I'll walk out.
Okay. I need you to walk so you'll be strong. I need you to do physical therapy, and I need you to eat healthy. Eat healthy. Okay, so you'll be strong. You've got to remain strong, Mom, please.
I can't stay here, Diane. I hate it.
I know you do,
I
Mom.
feel like I'm locked up in a jail.
Jeez.
I know. Well, you are. Basically, you're locked up
I
in a
know it.
nursing home.
I know I'm locked up, but I gotta get out of here. Please help me, Diane. You
I'm
got to.
trying to. I'm trying to.
And what do they say?
I filed papers in court, and I filed it the day after they removed you from your home on August 23rd. And the judge only signed it, he waited almost 2 weeks before I got the papers back. And I haven't heard from your attorney. I called her, but she didn't call me back.
Well, did the judge sign it?
He signed an order, he finally signed the order to show cause, and it was faxed over to me, so now we can go to court. But not until the 19th. I'm hoping that maybe we can go sooner.
How long does that take? Kleenex later.
I don't know, they want to argue reasons as to why you should be in my home instead of locked up in a nursing
I'd
home.
rather be in your home, not even than mine. I don't want to be by myself anymore.
I know, Mom. I know,
I don't want to stay here.
I know. I'm
I
sorry.
feel like I'm in jail.
I know, Mom. I know. I know. Are you doing anything?
Nothing. Nothing, nothing, nothing.
Are you reading any books or just
No.
watching TV?
Not reading. I'm not interested in reading. Not now. I can't concentrate on anything but getting out of here.
I'm sorry,
I
Mom.
can't sleep or nothing.
This is so.
I know.
Where's that water, Diane?
Right there on your table, Mom. Do you want to look in the camera, and do you want to say anything to anybody?
Whew. Broke into a sweat. Okay. Who wants to begin?
I'll let Craig begin.
I'll start. This, Michelle, very disturbing. I've seen this situation personally many times. As you know, I've been an advocate for victims of senior citizen financial abuse, elder abuse for more than 25 years. I've seen people like this in my office. I've gone to nursing homes. This is a very difficult situation. She said, "I feel like I'm in jail."
She is
Essentially,
in
she is.
jail.
She's locked up.
God.
And yet, if she were a criminal charged with a crime, she would have more rights. She would have the right to a trial by a jury. She would have a right to a speedy trial. She would be presumed innocent until proven guilty by beyond a reasonable doubt. None of these rights are afforded. People like this can end up losing all of their civil rights and locked up against their control by virtue of an order of a magistrate, not even a judge, a magistrate who is not elected, and a magistrate relying on a report by a psychologist who met with the elderly person maybe an hour. This is what's happening.
I will tell you, and before we go too much further, the camera can zoom in on this book. This book Tom Fields encouraged me to read. In fact, he let me borrow it. And I read it. And I don't usually read a book from cover to cover. But this book called The Retirement Nightmare, How to Save Yourself from Your Heirs and Protectors, was so absolutely unbelievable and so thoroughly documented that it has changed my whole position and has, in fact, pushed me to proceed forward on a subject matter that I didn't want to talk about, and that is the family. And I'm in the process of writing a book now called La Famiglia, which is the Italian word that says the family, when your children are murderers. And I don't know what the response is going to be, but I'm just saying that this has opened up my eyes. So thank you so much, Mr. Fields.
You're welcome.
For
Thank you for
your
reading.
kindness in letting me read this. So where do we want to go? You're the expert.
Well, there's a lot of lessons to be learned from a lot of different cases. And I'd like to start off by saying that I don't consider myself to be an expert in this area.
Okay.
There's a lot of people who are more experts, such as Diane, on these issues. I've never lived through a guardianship as Diane has and as others. And first of all, I'd like to mention that Diane's a PhD. She's testified before Congress. She's a PhD in psychology. This book is extremely legalese, I believe, compared to other books that I recommend, such as John Caravello's Marked for Destruction, which was a book by an investigator who rescued a woman from this kind of case and deals with that case. One of my biggest concerns is that many attorneys, including Craig just now, recognize that there's problems. But we aren't getting many attorneys to actually address the problems with the legislature in the way that they need to be addressed. There's a lot of what looks like things that are addressing them. There's the Ohio Elder Justice Act, for example, that's pending, that Mike Davila has introduced. Just one of a long line of efforts to deal with some of the elder abuse. But nobody's really getting to the issues that are the issues that I believe are really the outstanding issues dealing with the severely cognitively impaired people, such as in this case. And I'd like to make a statement, if I can, which I prepared ahead of time, just to be clear about this. One of the biggest problems, which is reflected in this case that the video was on, which Diane indicates she had power of attorney. She was the executive of her mother's estate. She had the documents, as in my dad's case, he had the documents. The problem is the documents were ignored by the court. And so one of the biggest problems, I believe, is this. It's kind of a contradiction in the law as far as how the law views things. On the one hand, to protect cognitively impaired older adults, as well as some not so cognitively impaired older adults, from being financially exploited, our courts ignore the wishes which these older adults have repeatedly and consistently expressed in writing, while unquestionably competent and able to resist undue influence regarding guardianships and nursing homes, forcing these individuals, as in the video, against their will into guardianships and nursing homes. And yet these same courts ignore the need for such protection, even when, as in my father's case, the older adult signs conflicting estate-altering documents that are brought to him by folks who not only know, first, that the older adult is just hours from death under a do not resuscitate order and on a morphine drip, but they also know that these documents contradict the wishes which this older adult has repeatedly and consistently expressed, again in writing, while unquestionably competent and able to resist undue influence. I find it troubling, and I hope the audience here does too, that our courts are not addressing the obvious lack of protection provided in such circumstances by our many laws, including the mandatory reporting laws, the Adult Protective Service laws, the guardianship statutes, the American with Disabilities Act, and the Older Americans Act. And I ask, could one reason this be that the litigants themselves are reluctant to confront this issue? In fact, litigants on both sides of such disputes adamantly insist that their position is adequately supported by the law. In fact, to argue otherwise would be self-defeating. So many lawyers know this to be true, and Craig has just indicated that he knows some of this to be true. Some even advise their clients accordingly. But how many are making the effort needed to address this problem?
I appreciate your remarks. Do you have anything to say about that?
Well, Tom's touched upon some very real issues. But we also have to remember, under the Constitution, we have 3 branches of government
Yes,
here.
we do.
And we have the legislative branch that is dealing with creating the laws. And then we have the judicial branch,
Yes.
where that's dealing with courts of law and trying cases. In all fairness to the court system, in my experience, the judges and the magistrates try to do the right thing. But bear in mind, Tom indicated that, the courts know what has happened. They know that there has been a change of documents. Well, they really don't to begin with. They come in blind to these cases. So they only know what is presented to them in evidence
At that time.
at that time. So they're bound to listen to that evidence fairly and impartially and then make a determination. So what's very important is you need an advocate in there that is going to get to that judge or to that magistrate.
Prior to the case?
Well, during
Or
the
during the
case,
case.
get to that judge, the evidence that is needed.
Okay.
If there's prior documents that establish what this person wanted, those have to be presented. It's just very important to get the right facts in front of the court. And as professionals, though, I agree with Tom. I think that attorneys, as well as judges and magistrates, should work with the other branch, the legislative branch, vote for candidates who support
that.
these changes. Correct. Or write to your representative and say, we need changes in the law here. And I do that kind of thing. The legislative process is very slow.
Well, may I ask just a direct question, since you are in the court itself? This is what you do. And have you encountered situations, just by observation, that would tend to support what Tom's talking about, which is there is a discombobulation of hearing and able to be the issue of this is egregious, okay?
Yes, it is.
And it's offensive.
Yes, it is.
Because America is aging rapidly, and $11 trillion of money is nestled in this group.
Correct.
And I know how this is going to play out. I just know. Kids are going to see opportunity. Yeah. It's just too easy. It's
Correct.
too easy.
That's
They see
correct.
opportunity. So how do you advocate in a courtroom setting so that these things do not occur? I mean, what does one do here?
Each case is different.
Each case is
Each case is different, and you've got to do the best you can with the facts in front of you. And you have to accept the fact that your case, these facts are going to be decided probably by a magistrate.
That is so disturbing.
I was involved in a case just last week where
magistrate.
the magistrate, even on the record, stated, well, the rules of evidence, we don't really apply them the same in these cases. So they depart from basic rules of evidence. But you've got to do the best you can. You're in battle, and you're advocating a very important interest. You're representing that older person there, and they're crying, and their whole future is at stake here. You have to do your best. But on a larger perspective, I think what we have to do is look at getting more judges. There's going to be more cases like this. 70% of the nation's wealth is now in the hands of people older than 50. That's the challenge you're talking about.
Yeah.
So there's going to be more and more of these kind of cases as kids see an opportunity to grab up their quote-unquote inheritance. They're forcing parents into guardianships or nursing homes against their will. There's going to be a lot of cases. Well, unless we have more judges to pay attention and spend time on the cases, it's going to be a very big problem because they're busy.
Well, what are your thoughts on this, Tom?
There's several points that have just been discussed, and there's so much wrong with the system. It's hard to pick one or two things to start with to focus on. But just as far as lawyers and their role with the legislature. There was a guardianship committee by the Ohio Supreme Court Advisory Group.
Okay. Now, are these attorneys or are these?
Members of the court.
Okay, they are members of the court itself.
As far as I know.
Okay.
And I don't know a lot about it. I know that I had some interaction with the AGs, the Attorney General's Elder Abuse Commission, that said my concern should be before that committee. The committee turned around, the spokesman, the representative on the commission for the committee said no, it didn't. So there's some disconnect there. Why there's a disconnect, I can't explain. Nobody's tried to explain it, but
So where are you going to report your information to?
I've reported to the commission, which has said that they were going to boot it over to the committee.
Which says,
but the committee said not here,
here,
and they knew that the committee said not here because a member of the committee was on the commission. So this is the way. This is the problem with the government. In fact, as there was an interview in South Florida just 2 days ago by CBS 4, Channel 4 in Miami, that was interviewing two individuals from a group that I'm familiar with down in Florida, headed by a Dr. Sam Sugar, who is pushing legislation in Florida and believes he's going to have the Florida Medical Association behind it on the guardianship issues. And
what is his
there's
posture?
Senate Bill 412 and House Bill 1157.
Okay.
And he's trying to work with the legislature. I've tried to work with the legislature, work with the bar. I've tried to work with the bar. In the discussion, it was a short interview, only about 10 minutes long, with himself and a woman named Lydia. They mentioned that the host of the program, another Michelle, indicates that she tried to get the Florida bar to respond, and the Florida bar indicated that it was opposed to the legislation, and then called Sam and his group extremists. I can tell you they're not extremists. They're people who have gone through the problem. Okay, but that's...
He's a medical practitioner.
And he's a medical practitioner.
And they're calling them
They're calling him and his group extremist.
Interesting.
The point being that they're talking about changes that need to be made in the evaluation process before you put a person in a guardianship. Sam's saying it should be doctors, not just people like magistrates that should be on the committee. That the committee should make a uniform, should make a unanimous recommendation for the individual to be put under a guardianship, not a split decision. If somebody who's supposedly objective feels that it doesn't, shouldn't be, then you don't have unanimous. You don't have. It should be a higher threshold. They make reasonable. And this is just the nomination process, it's just the appointment process. They're talking about certain flaws that they see in the process. And again, they are better spokesperson for what they're aiming at. You have people who want to get rid of the entire guardianship system because it's so corrupt. There are cases reported almost daily of judges who are found guilty of corruption in one way or another in these kind of cases.
Kickbacks and that type of thing.
Kickbacks, whatever it is.
Whatever.
There's a lot of examples. And that's what's reported. There's many more cases that aren't reported that never even get the attention. And that's one of the things I really appreciate about what you're doing here, because you're giving at least a chance for people to at least have a contact that they can find out more of these cases.
Well, let me just ask you, not to interrupt the dialogue, give your phone number. I need both of you. Just stop right now and give your phone number. What's your phone number?
My home phone, which is the only
You
phone
want people
I have.
calling you at home? Okay.
They're free to.
Okay.
440-255-7693. My wife won't like it, but
I was going to say.
she's already said thanks for not giving it out last time. but
Okay.
She's very understanding.
Good. And Mr. Matthews?
Michelle, my office number is 937-434-9393.
Okay, fine. And you have offices in Dayton and Cincinnati?
Correct.
Do you have networks nationally where people because this show goes into other states, where they can get referred in to other attorneys?
I've been contacted by people all over the country,
I'm sure.
state of Washington, Texas. I've been called, I'm dealing now with someone that's in Jerusalem.
Oh my gosh.
So I will find them the right attorney.
Help. Okay, that's
correct.
very important. I need someone to walk me through this system. She gave an account here where a sister, and I just sat up in the bed. The mother had taken the 3 sons to vacation in Florida and excluded the sister from going. I don't think it was a deliberate act of omission, but the sister proceeded to vet by petitioning the court for guardianship for her mother. And I'm just trying to understand, how easy is it to do this?
It's easy to do it.
It's easy to do this.
It's to start the process.
It's easy to start it.
Anyone. You could, this afternoon, you could go to your probate court of the county where the person
Hamilton,
is,
yeah.
and file an application to declare someone else incompetent and be appointed their guardian. Anyone can do that. You just pay the filing fee. But then it starts a process.
Okay.
And the court has to have an evidentiary hearing and then make a ruling. The problems are that, one, courts are considering evidence from non-physicians. So someone could file an application to declare you incompetent.
You don't think I've thought about that?
And your competency could be determined without ever having the testimony of a medical doctor. I've been
Is
involved
this
in...
true, Tom?
Oh, in fact, there was a Supreme Court case, a New York Supreme Court case recently, where somebody wanted something changed, and the lawyer was called up, dictated the change, but he was busy in court, so he had his assistant take the change and do it. But the assistant was busy, so basically the only people that were available to execute, to supervise the execution were the witnesses to the document, and the court ruled that that was good enough.
The witnesses
So
to
it didn't
the
need a lawyer,
document.
didn't need a doctor involved, didn't need anything. Just needed to say the witnesses said it was okay, and the witnesses could have been part of the problem.
Continue.
Well, I think the changes that Tom was talking about, one of them, I think that for any determination of incompetency, where you could end up jailed, so to speak, for the rest of your life, a doctor should be involved. There should be a doctor.
I think
examines you,
intuitively, is
a
that
medical
a
doctor.
medical doctor?
A medical doctor.
To determine, couldn't they do tests to determine memory and cognitive?
Whatever, yeah.
Or
You've got
whatever.
neurologists and such
Right,
know how to
right,
evaluate
right.
these things. It's
Wait,
not an easy
I'd like to
evaluation.
express a very deep concern there. Remember, in describing my background, my own case involved two doctors, and they
Yeah.
both okayed contradictory documents, the second one right underneath the first one, within hours of the time, and my dad was in a morphine drip on both of those cases. The doctors, typically the medical testimony, and I have records from the Ohio Legislative Service Commission to this effect, are looking at whether you're alert-oriented times 3, which means are you hallucinating, are you in a coma, are you responsive? They're not looking at things like, are you being taken advantage of? The article by Dr. Hall, which is in some of the documentation I've shared with you, is superb. But they should be looking at questions that doctors are not equipped to look at, which, at the time your science says that's the important time, which is questions about you even, did you ask the lawyer to come in, or did somebody send a lawyer in to you? Who's driving the matter should be a very important question. Are questions being asked that if people were there that they would ask to make sure that you knew what was going on?
That's absolutely correct. If you have a headache, you don't go to a foot doctor.
No.
But the problem is any doctor can testify, even non-doctors, psychologists can testify. So what the court needs to look at, establish clear standards so that the expert who's testifying, I be a physician, and they should be a physician who specializes or focuses in dealing with issues of competency.
Can you, as an attorney representing the individual, the aggrieved party, bring a doctor in? Can you
Correct.
bring a physician in to provide testimony on behalf of this person?
And in fact, not only can you, you should. The advocate for the elderly person should bring in a physician. Have your client agree, look, you need to be examined here. I want you to be examined by a neurologist, or there can also be non-medical doctors, say a PhD psychologist, clinical psychologist who focuses on assessing neurological functioning and mental capacity. There's testing that can be done. Bring in that evidence. Have your client examined, and then the court should be looking at that and listening to that, and not listening to some other doctor that, as Tom was indicating, might have been treating this patient for a cardiac procedure or so. Is not looking at the big pictures, just looking at is the patient recovering from the anesthesia. That's a whole different question then. The question is, does this person have mental capacity? Do they understand the nature of the transactions that they're involved in if they're signing legal documents?
Yes.
Do they understand what those legal documents are?
Wait, let me interrupt one more time. First of all, there's situations where you know the person got questionable competency.
Okay, you know this?
Well, you know when you watch the video with Diane's
Okay.
mother, for example, you know, there may be questions of her competency. So you know ahead of time that there's some questions. And so you might want to have a medical, depending on the situation we're talking about, so let's talk about the kind of case we just showed. Okay, so when you're going to a competency examination, you know, you need doctors to examine competency. And again, should they be knowledgeable of competency? But again, you have to look at the issues, are they being taken advantage of? So you need not just a doctor. You might need a team of people, and they have fast teams for other situations, so why not a fast team for this kind of situation? You know, and don't ask what the acronym FAST stands for, but I'm not familiar with it anymore. But it's basically, you know, social workers, law enforcement working with other professionals. And so you need somebody who knows from law enforcement what exploitation is about and knows what to look for, which doctors don't. And doctors admit they don't know. Most of them don't know about it. And doctors have written, and studies have been done to show most of them don't know what to look for. And that's why you need not just the doctor, not just a member maybe of Adult Protective Services, when people complain about their lack of knowledge about what's going on, to law enforcement, which, you know, there's a big conflict between Adult Protective Services and law enforcement, especially in a state like Florida, where I'm familiar with, that they're at odds with each other. They even had a law passed that said they were going to work together because they weren't working together. But you also need to have a protocol. You have to have a list of questions that need to be asked in these kind of situations. You know, one for the guardianship competency, one for when it comes to wills and deeds and trusts.
Yeah.
When you have somebody that's cognitively impaired, you have to have questions that can be asked that are a protocol. Just like in the medical field, you have protocols, and the people have to follow. And the people who are doing these examinations, whether it's the lawyer at the bedside or the doctor who's been asked to do something, they have to follow the protocol. And there should be accountability if they don't follow the protocol. And it should be simple. It should be a simple protocol. I mean, it should be just a series of answers and questions and answers that you ask for, and you record, and then everybody's got a record of it. And you see how the person evaluates. If there's not, if the person can't say, for example, what their true worth is, or if they, you know, and you impress upon the person, this is important. You give me the right answers because it's going to be possibly used in a court of law. And if you want your things to be handled right, you know, you're going to give me the right answers. And if you want to decline the whole thing, just say you want to decline the whole thing. We'll make a record that you want to decline it, despite the fact, because basically, you know, if you don't appreciate the importance of it, that should be a part of the question of competency. Do you appreciate the importance of what you're going through?
Well, I don't mean to interrupt, but this is, I'm still not clear. And my thing as a advisor is I'm always following the money. And I'm trying to figure out why a child would want to be named guardian over a parent when the court is very careful about how money is spent. Am I misunderstanding that?
Yes, the courts are not careful.
Oh, they are not.
No, they're not.
I don't know if I would go. I don't know if I would go that far, because there is a guardianship accounting. If a guardian is appointed, why is a guardianship application filed? There can be various reasons. You could have a situation where an out-of-town sibling is aware that mom or dad is infirm, starting to have dementia problems, and another local child swoops in. Maybe they don't have a job. Maybe they've never been very successful. Now they see they can start living with mom or dad. They can start getting access to mom or dad's checking account. They start writing checks. They sign the parents up for credit cards. I've been involved in
That is a part of guardianship latitude?
This is before the guardianship.
Oh, before the guardianship. Okay.
So this other sibling sees mom or dad is being taken advantage of.
Yes, right.
And they want a court to stop this, because mom or dad, in fact, are being taken advantage of because they don't have competency.
Okay.
And so you want to bring the court's attention to this to stop that from occurring.
So the sibling out of town would file a petition to the court. Is
might
that
hire
correct?
me, correct.
Okay.
Might hire me to file an application to have mom or dad evaluated to determine is mom or dad what they're doing. They've just given $200,000 away to
Their son.
one of the sons for nothing. They get nothing for that. Now they don't even get a promise of continued care.
Because this is where I'm trying to follow this money path. So The son's already moved in. He's already behaving as a predator.
Starting to write checks.
Yeah, starting to write checks. They clearly put him on the account for him to write checks. And so the sibling out of town retains counsel to petition the court for a mental competency. I'm just trying
to determine whether the parent is incompetent.
Okay.
If the parent is incompetent, then the court is empowered to appoint a guardian.
And the guardian would not necessarily be that sibling, or it could be.
It could be the sibling.
But
it
not
could-
necessarily.
Or not necessarily. The court has that authority. The court could say, there could be a fight. It could be that the local kid who's taking advantage says, I want to be the guardian. And then the one that's out of state saying, no way, you're taking advantage of mom or dad. I want to be the guardian. And the courts oftentimes act in like the King Solomon, cut the
I'll
baby in
cut
half
the
and say, I'm not going to do either one of you. I'm just going to pull from a panel of local attorneys to act as a guardian. But at
Okay.
least you stop the bleeding in that situation.
Michelle, can I interrupt?
Yeah.
Everything Craig says is true in some cases.
Okay.
The problem is you can't tell many times which kind of case you have. And that's the problem.
What do you mean?
Did the mother want to give the $200,000 to the child?
Well, that
Which
parents
might
are going to
well be.
say, yeah.
And did the child, did she want the child to live in her house because she wanted to help the child? Or was she being taken advantage of? And of course, the courts say, well, that's what we're here for. But how do you establish, when it's time to establish, that she wanted to give you the $200,000 so that it'll hold up in courts and the courts won't go into this long debate about it? How do you go about it and make it clear so that there's no conflict over it? And how do you do it?
Look at the history
Well,
in
I'm
a case
just
like
gonna
that.
Well, the
say,
fact
yeah.
is, but many of these cases, the procedures for doing it are slipshod, if there are any. And basically, here's a statement from one case down in Florida. The issues that we're talking about here are complex, but at their core, the purpose of advanced directives is to avoid the uncertainty, including the vagaries of the probate. And a lot of guardianship cases are in probate or family courts. This is why they are the first thing attacked or hidden without mention in the proceedings.
What, the advance directive?
Right, the advanced directives. They're almost always going to be attacked by people
Well, let
who
me
want to
stop
overthrow.
because we need to make sure, because we don't want to get over the head of our viewers, because we're now into legal process. What is an advance
An
directive?
advance directive is a health care document. In an advance directive, you're telling the world that if I am unconscious or if I am unable to communicate for whatever reason, I've had a stroke, I'm in a coma, whatever, I appoint X to be my health care attorney, in fact, to make decisions on my behalf. That's a health care directive.
Okay.
And health care directives really don't get involved that much in guardianships.
Okay,
Health care directives advanced directives are used for medical procedures. Where the problem comes in is with powers of attorney. Powers of attorney are used to get into checking accounts, get into financial accounts, and why I think it's important to look at the history. So the local kid moves in,
Yeah,
and the one that's out of state might be in Washington.
Yeah.
He sees that the local kid has taken $200,000 of mom and dad's money for nothing, essentially. I mean, it doesn't cost $200,000 to live in mom's house, eat mom's food, be warmed by the heating bill that mom pays for, and you're getting free rent, and you're taking $200,000 of mom's money.
okay.
And Tom said, well, maybe mom wanted to do that. Why? Then you look at, has mom in the past favored this one child? So you look at mom's will that might have been written 10 years ago. And you see, well, no, mom wanted her estate to be divided equally between
which
the
is
two
most
kids.
parents, yeah.
So yeah, so you see that doesn't really make sense. Now, why now, after mom has suffered a stroke or some medical impairment, why now does mom want to essentially turn the keys over to one of the kids and causing the other child, who she had loved and treated equally the rest of her life, all of a sudden they're written out? So
The time to answer those questions is the time that mom turns the keys over, not in a court case after she dies. And
Correct.
again, advanced directives are not just health care directives, which, and I think that
in
Craig-
Ohio they are.
Advanced directives are wills. A will is an advanced directive. It tells the courts what you want to do with your will. A
Not
power
in
of
Ohio.
attorney
Not in
is an
Ohio.
advanced, maybe you don't call it an advanced directive, but that's the idea. It's an advanced directive. It's telling people ahead
giving
of time.
instructions.
It's instructions. And you're telling the courts how you want things handled. And this is the problem, because the courts are not honoring the advanced directives. The people, are not, you can't rely on the courts to honor the advanced directives. How do you make the courts, how do you establish advanced directives in such a way that the courts will honor them? And if you're going to change an advanced directive, that you do it in a way so the courts know you want to change that advanced directive so that there's no doubt. How do you remove the doubt? Because what's happening is because we're not doing things in a way that should be done, we have this long out litigations. In the case that you saw the video of, they went through over about $15,000 a month in the woman's accounts. While she was in her guardianship and nursing home, $15,000 a month. She had reverse mortgage on her house for $200 and some thousand. She had savings of another $100 and some thousand. In 24 months, it was all gone. It was all gone.
That lady we saw in that video.
That lady we saw. This is a typical fact pattern.
Who got the money?
Well, one of the parties involved in the guardianship for the court, one of the court's appointees, got the right to sell the home. This is typical. People who get involved in wanting these guardianships, they also act as the brokers of the case. They're getting, therefore they make money, or their spouses do. This is going on here in Ohio too. There's a lot of misbehavior going on that isn't called misbehavior because it's all legal.
That sounds like a conflict of interest.
There's a lot of conflicts of interest involved in these
And
cases.
the thing that I'm trying to pull out is because this can sound very legalistic and academic. It can, until it happens. Now, I do know of a situation where, because when parents get sick and they get afraid because they're elderly, and there's always one little puppy in the litter that's a problem.
The needy puppy.
The needy puppy, the needy puppy. And the parent lets him come in, and it's just a mess.
And the problem, Michelle, is that I think Tom's using a term that most people would call it a will.
Okay.
And the problem is that people change their wills. So
They
in the
do
example,
codicils, yeah, they
in the
do.
example that we're using here, the local kid moves in,
Yeah.
takes over, living in mom's house
Okay.
for free, rent-free,
Yes,
eating mom's
yes.
food, starts taking over mom's accounts, and has mom sign a new, what Tom would call an advanced directive, a new will that gives everything to him. And then now, say mom dies, now you have to go to the court
And
and
fight it out.
And fight it out, because the local kid says, here's mom's will. She said she wants everything to go to me. And the other
I
child,
was like, excuse me?
wait, this is different than what she's wanted the rest of her life.
I'll tell you how that kind of case could be handled.
Tell
Now,
me.
there isn't one solution for a lot of cases, and maybe not even for the case that he's talking about, but something that applies to his case. There's law in Ohio, which I addressed, trying to amend it, that's better law here in Ohio than other states, dealing with what they call self-proved wills. And that means that, Michelle, you could take your will today before a court and prove it's valid while you're still alive. And the purpose of that is so that if there's a contest on that will, if that will is challenged after you're dead, the court says, wait, we've already had that contest. And it's very well done in Ohio because basically it requires notification of parties with interest who might want to challenge you while you're alive and can answer their challenge.
What is that called
It's
again?
called self-proving a will. And
Isn't that where you present and you file? So they have a matter of record, they have the will on
it's
file?
more than just that. It's actually giving the parties the opportunity to challenge it. It's
Your will.
your will while you're alive.
Oh,
Now,
man,
there's a
okay.
loophole in that.
Okay, give me the loophole.
And this is why I tried to amend it. And the Bar Association fights it, just like they fight everything else.
Okay.
The problem with it is you've gone to the bother of self-proving your will to protect your heirs from a challenge. And then what happens is you get into a condition like Diane's mother was in,
Right.
and somebody gets you to sign another will. And all of a sudden, that will is now your last will. And there was no protection put in place to make sure you couldn't be taken advantage of, because that's what's missing in our law. So I proposed an amendment to that code. I said, let's have a will that's not only self-proved, but self-propagating. Self-propagating means that if I'm going to make a change to that particular will, the next time I make a change to my situation like that, I go before the court and say to the court, I want to make that change, and if in that change I want to end the self-proof process, I can end the self-proof process too. But I make sure that the very next time something happens, the court is aware that something's happening, and that people have the opportunity to challenge me at that time again, because that's the self-propagating part. And it's very
That's
reasonable.
interesting. I
But
think that's very reasonable.
everybody thinks it's reasonable except for the Bar Association. They don't want to give you that right. Every right I have proposed, every protection I have proposed in 23 years, the Bar Association has stood up against. Now, this is a matter of trying to work with the members of the legal profession. This is trying to work with members of the legislation, and you can't even have a good dialogue.
Well, I think, though, that time is on your side, Mr. Fields.
With your help and help
No,
of others,
no.
yes.
I'm just telling you, it's a numbers thing now. There's too much money on
But
the
if
plate.
people don't know what's been proposed and how the authorities have responded to them, because they should be outraged. If they knew what the authorities are doing and how the authorities have responded, they would be outraged. But most people don't know because it's not being reported.
But I'm here to tell you again, it's just like everything else. Because of the massive demographic shift we're seeing in this country and the wealth shift, I absolutely believe that some things are going to begin to move.
I hope you're right.
I have to, because it's just like the whole issue of people now understanding that Medicaid means you're poor. I mean, people would go into nursing home, they say, well, you know, they're on Medicaid, what's the big deal? I'm like, you don't have an estate because your mom's on Medicaid and that's the end of it. People didn't understand that contextually because it didn't apply to them.
You know, it's interesting you introduced Medicaid, because we have a couple of Ohio lawmakers, Latourette and Budish, who were responsible for what some people are calling welfare for the rich. Because it used to be against the law for a lawyer, this is what I understand from what I've read, it used to be against the law for a lawyer to advise his clients to impoverish themselves so as to be able to go on Medicaid.
Okay.
And they changed that law because they wanted to make it easy and help their wealthy clients impoverish themselves so that they could get Medicaid benefits.
Well, I'm going to have to
Medicaid was
take
supposed to be a
exception.
safety net.
Yeah, Medicaid is a safety net for
What
the
people are
poor.
doing is they're taking advantage of it in the way we're talking about. The people that don't need it, they want to save their money, understandably so, for other purposes like their children. But what they're doing is they're taking away a safety net that was intended for people who didn't have anything to give away to start with.
I don't want to get onto that because actually Medicaid has gotten pretty tight. And there is a 5-year.
A 5-year look back now.
And Congress is getting ready to take it
Well, Michelle,
further. But,
I have to agree with what Tom is saying
okay,
here.
well, give it to me.
And because Medicaid is getting tight, the reason it's getting tight is because people who don't need it are taking advantage of it. So
Oh,
you've got
that's
a mom
horrible.
or dad that might have $3, $4, $5, $6, $1 million in assets.
Yeah.
And now mom and dad are getting older. And the kids are thinking,
Oh, yeah.
boy,
money,
we got
money,
a
money.
$1 million
yeah,
inheritance
yeah,
here.
Yeah.
And then they look down the line and they say, well, gosh, if mom or dad goes into a nursing home,
I'm done.
it's going to cost $10,000 in 1 year. $120,000 is gone,
gone.
and it's all gone. So how do we protect our inheritance? We have to get the money from mom and dad, so then they can apply for Medicaid, and they don't have any. Then when they file the Medicaid application, do you have any assets? No, we don't have any assets.
So
And
Because
that might be
this
the
is what-
reason why they gave the $200,000 away in the first place,
is to be able to
to
strip
be able
the
to make sure their
estate.
kids got the money and they can get and they don't have to spend it.
So it gets very entangled. But if you're going to be giving, and this is, you know, I'm not here to discuss the rights or wrongs of Medicaid. It's a fact.
It is what it is.
It's Medicaid planning,
Yeah,
and a lot
it's
of
a
people
part-
do
yeah,
it. And some of these families say, I'd rather have the state pay for mom and dad's care than mom and dad, even though they could afford to do it, because I want mom and dad's money. That's
Right.
what it comes down to.
Well, see us back to this $11 trillion asset pool.
Correct.
Which children are looking at. And I'm just going to tell you, only because I've been in practice for so many years, I tell seniors, including my parents, that's your money. If you want to give it to the SPCA or whatever, you're not entitled to assets that you did not earn.
Correct. Correct.
And it's offensive.
Right.
This whole thing about children fighting, and now you're saying that if the court appoints a child, the little puppy that never could eat enough, that male or female, son or daughter, is now guardian, and they have the right to invade assets.
No, I didn't say that.
I know
didn't
you
say
didn't.
that,
I'm just
no.
trying to think
And-
it out in my head. I
and
didn't
that
say you
doesn't-
said
no,
anything.
and that doesn't happen.
Okay.
Once a guardianship is in place,
Mm-hmm.
I have found in my experience the courts do monitor. Once a year they record a detailed
And
accounting.
don't they have to post a bond?
They post a bond.
Right,
and
cash.
Correct. So if there's ever evidence that that guardian is using the ward's funds for anything other than helping the ward, that guardian can be in trouble.
My God.
You know, talk about
So that's
monitoring.
good.
Let me mention
Now,
about
our time
monitoring.
is wrapping up, so
This will be
make it
quick.
fast. Okay.
Down in Florida, they have by law established the ability for counties to have an office of monitoring. A monitoring
Okay.
I forget what it's called, the Office of the Monitor. And only 3 or 4 counties in all the years it's been around have even established an office to monitor the guardians. In fact, that was a matter of hearings down in Florida. We don't even have such an office by our law up here, as far as I know.